Judge Morrow.
Yes, good morning, Mr. Finley.
Good morning, Judge Morrow. That is my case. I did have on the announcements. I need to speak with Mr. Allen if I can before his position is called.
Okay, so can you call courtroom 2 and we can go to someone that's not one of Mr. Finley's clients while he speaks to Mr. Allen?
Over there, that's here.
And this is ready, Judge.
And can you just tell me what the phone number is one more time, please?
It's 404-612-2392.
Great, thank you.
You're welcome.
Excuse me. Good morning, Judge. This is Ms. Lewis. I'll just let you know that Mr. Allen's mother is also on the line.
Okay, thank you, Ms. Lewis.
Carrie.
All right, where do we go now?
We can go to,
Annex.
no, we can just go ahead and move on to the next case while we still do one.
Okay.
Well, Your Honor, I have positioned the latter half. I think Attorney Finling has the beginning half.
Okay, so
Who has probation?
I do.
I got position Moss for you for probation.
okay. All right, so good morning, Ms. Middleton.
Good morning.
Let's see, who do we have at 7 South?
Mr. Moss.
Good morning, Mr. Moss. I'm Judge Eric Morrow. This is the probation revocation calendar. We're holding this calendar this morning by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Good morning. Yes, sir, Judge.
Okay, thank you. Ms. Middleton?
Thank you, Your Honor. Mr. Moss here before Fulton County State Court on October 1st, 2018 for the charges of driving with a suspended/revoked license and was sentenced to 12 months of probation and to complete 50 hours of community service. He failed to complete 50 hours of the community service and he has 6 months, 11 days left, but probation is going to recommend that he receives credit for the time that he's actually been incarcerated and close the case.
Is that 10 days that he's been incarcerated?
I believe he's been in there longer than that, Your Honor. I can check. Give me 1 second.
Okay. And if he's been in, has he been in just on this suspended license charge?
I believe it was other charges as well.
Okay. Ms. Helen, do you know?
I'm looking it up now, Judge.
I have it, Your Honor. He's been in for other charges as well since July 15th, 2021.
Ms. Helen?
Yes, Judge. We agree with the probation's recommendation to close the case.
All right. What other charges? I'm reticent to let him to close a case when he's in custody for something else, and he did not do. Did he not do anything because he's been in custody? Is that why he was unable to complete 50 hours of community service?
I'm sorry, were you asking me, Your Honor?
Anyone who can tell me.
Okay. Believe he's been in custody since the beginning of his probation.
All right. All right. So it's probation's recommendation. So I'll accept your recommendation, Ms. Middleton. Time served. Good luck to you, Mr. Moss.
Thank you, Your Honor.
You're welcome. Is that your only case today, Ms. Middleton, Officer Middleton?
Yes, may I be excused?
Yes. Have a good day. Thank you.
Thank you.
They're ready for the Cobb County case? Okay, come on. Come on, Mr. Allen. Y'all switch seats for me? Judge, we can go back to position 1, Mr. Allen. He's ready.
Okay. Thank you. What's your announcement, Mr. Finley?
Yes, Judge Morrow. This will be a negotiated plea, Judge.
Good morning, Mr. Allen. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Okay. Can you raise your right hand for me? You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down. Thank you, Mr. Allen.
No problem.
Good morning, Ms. Mitchell.
Good morning, Your Honor. The state's plea recommendation in this case is 12 months to serve, credit for time served, 147 days, balance probated, no further contact with Ms. Natasha Allen, a stay away from address 3871 Red Wine Road, Atlanta, and a FVIP class, and no alcohol, drugs, and weapons. Nothing further, Your Honor.
Mr. Finley?
Yes, Judge Morrow. So that was not our understanding. On the offer, it does have BS, which I understood to mean balance suspended, which was the offer that I approached Mr. Allen with. It says time served, and then it has BS.
No, I see it, but we can't have a balance suspended if he has to complete the FVIP program, right? I mean, that's going to take him at least 6 months, so we're going to have some way to monitor him with regard to completing that program, correct?
Understood.
You want to talk
Okay,
to him right now to let him know that he's going to be on probation at least until he completes that course?
Yes. Yeah. Let me call and review that with him.
Well, I've said it and he's sitting right there.
Okay.
Mr. Allen,
Sir.
you understand that if you accept this offer that you're going to be on probation for the time for you to enter into that family violence intervention program. You do understand that?
Yes, sir.
Okay, Mr. Finley, do you want to, it's up to you. Do you want to have another conversation with him or?
That's okay, Judge. No, that's okay, Judge. As long as I would ask that once Mr. Allen does complete that course, since that's the only other condition on here, that he could be not reporting or balance be suspended, sir.
Okay. I see that Natasha Allen is on the line. Ms. Allen, if you would like to speak regarding this matter, I'm happy to hear you. You're not required to speak, but if you would like to speak, I'll need to swear you in, okay?
Good morning, everyone.
Okay, hold on now. If you want to speak, I'm going to ask you to raise your right hand for me.
Okay, I haven't experienced this, so I don't know how this goes.
That's fine.
I'm sorry.
Yeah, you don't have to apologize, Ms. Allen. Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. What is it that you'd like to tell the court?
I would like to tell the court that Desmond, it wasn't any violence or anything. He just has a drug problem. And his aunt and myself have got him into the Potter house. And as soon as the court allowed, they would pick him up and transfer him into that program. And so I go see him on Saturdays weekly, except for the weather conditions don't allow. And we've talked about him getting into the program. And so that's what I would like to ask the court, that he be allowed to get into that program. He has nowhere to live, and so it would be a hardship. I'm retired myself with a few disabilities, and so I would just like to see him transition into that program and become who he was. He was a college student, very smart, but again, we went through life happens. And so I would just like to see him do better, and that the court allow that, please.
Ms. Allen, you know that if he accepts this offer, that he's not to have any further contact with you or be around your home. Is that your desire?
No, I guess I don't understand it, because there were never any violence. I guess that's what I'm trying to understand. That wasn't it. And so
you're saying
I don't
go ahead.
I don't live at that address anymore. I now live with my sister. due to disabilities. I couldn't walk and stuff, so family had to help me out. So I don't live at that address.
So I guess
You
my question to you is, and Desmond is your son, is that right?
Yes.
All right. So I guess my question is, do you want to have contact with him or not?
I would like to make sure that he's okay, and how the program is going and how he's progressing. I would like to know that, and hopefully, he can recover, and it won't be a result from being on drugs. So, yes, I would like to get information from him from time to time to see how he's doing, if he goes in, if and when he goes into that program. And it is in Jefferson, Georgia.
Who do we have on from pretrial?
Good morning, Judge.
Good morning, Ms. Harrison. Can you tell me Mr. Allen's history, please?
Yes, I'm showing 5 cycles. Last arrest was January of 2021. That was for theft of shoplifting and willful obstruction. I'm also showing an open case for criminal damage to property and simple battery. That case number is 22 SC 180603.
Okay. Thank you. So, Mr. Finland, my sentence would be that give him credit for the time served, no further violent contact with his mother, Ms. Natasha Allen, the Family Violence Intervention Program. I would waive his fees while he's on probation, but given his history, I would want to monitor him, but I'll waive the fees for the entire 12 months. So if that's something that he desires, that would be the sentence.
Understood, Judge. Mr. Allen, does that sound good to you, sir?
Understood. Yes, sir.
And yes, Judge, we would like to proceed with that.
All right. Anything further, Ms. Mitchell?
No, Your Honor.
Mr. Allen, it's my understanding that you wish to plead guilty to battery, family violence, and battery. Is that correct?
Correct.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury? You don't want a jury trial, do you, Mr. Allen?
No.
Has anybody forced or coerced you to plead guilty?
No.
All right, I'll accept your guilty plea, Mr. Allen. The sentence will be 12 months to serve 147 days, credit for time served 147 days, balance probated, no further violent contact with Natasha Allen, Family Violence Intervention Program. Let's see. I am going to waive the probation fees while you're on probation to help you get and stay on your feet, but you're going to have to be on probation for the entire 12 months, okay?
Thank you, sir.
All right. Anything further on Mr. Allen?
Nothing further, Judge. Thank you.
Judge,
Yes, Ms. Allen.
I'm trying to understand where he goes directly, and that program is for 12 months. And I know something else is coming up. I know enough something is coming up in April. So I know he'll probably remain there, or he could go to the Potter's house and they'll transport him, from my understanding. But, I guess you guys will have to get more information about that. So how that would be done.
I don't know anything about his other, those other charges, Ms. Allen, but
Okay.
but regarding these charges, that'll be the sentence of the court, okay?
Okay, thank you.
You're welcome. You have a good day now.
Thank you.
Who do we have next?
Excuse me, Judge Morrow, this is Katrina.
I
I just want everybody to know, probation wants everybody to know that, look in the chat, she's given it appointments for the people who've been placed on probation, so they'll know when to report and what time. So that's why she's probably referring to April the 1st, Mr. Allen's report, April the 1st at 11 o'clock at probation. So they need to look in the chat every time somebody's on probation for probation, so they know when to report. So I just want to make that known.
Thank you, Ms. Lewis. That's that's a change from what we've normally done. So does everybody have that so that your clients will know where they're supposed to report and when they're supposed to report? Okay.
Judge Morrow, the reason being is because I'm not receiving half of their paperwork for them signing saying that they're, as far as their contact information. So that's why I'm putting it in, because I have not received some of this information. So let them know that I do have an appointment on that day. That's why I was doing it this way.
Okay.
So
That's, no worries. Just as long as we know how we're gonna get it done. So everybody is, especially the public defenders, know that the information regarding probation is going to be in the chat from now on. All right. Let's see. Who do we have next?
Got add-on one, Mr. Conley.
That's my case, Your Honor.
Good morning, Mr. Murphy. How are you?
Good. Judge,
And
this is a negotiated plea from Judge Besson, and it came back down to you due to the litigation manager was on FMLA. So that's why we're here. But today we're here to tender a plea of nolo contendere to a amended charge of disorderly conduct with 12 months to serve, credit 365 days, because he's been in custody since, I believe, July of 2020.
All right. And that's your understanding. So it's your case, Mr. Segura?
It is.
Good morning. That's your understanding of what the plea is?
It is.
Okay, very good. Good morning, Mr. Conley. I'm Judge Eric Morrow. This is the state all-purpose calendar. We are conducting this calendar today by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, thank you. You can put your hand down. Mr. Segura? Anything further?
I do. Isn't anything for me?
Okay, Mr. Murphy, anything further?
Judge, the paperwork was submitted. I brought it to clerk's office right around. It's stamped in for February 28th, so you should have it. I met with my client on February 23rd at the Fulton County Jail in person, and he was aware of the rights that he was waiving by tendering this plea. You'd ask that you accept it, Your Honor.
Mr. Conley, it's my understanding that you wish to plead nolo to disorderly conduct. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You have to speak up for me.
I said no, Your Honor.
You've been represented by counsel. Are you satisfied with your counsel's representation?
I am, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading nolo to it, you're giving up your right to a trial by jury? Is that a yes?
I understand.
Has anyone forced or coerced you to plead nolo?
No, Your Honor.
I'll accept the nolo plea as negotiated. Good luck to you, Mr. Conley.
Thank you, sir.
Thank you, Judge. That's all I have.
Have a good day, Mr. Murphy.
I'll see you this afternoon. Thank you, Judge.
Okay, very good. Who do we have next?
So Annex, good morning, Your Honor. We have before you position 15, Miss Mack.
Okay, good morning. I have down, this is a negotiated plea.
That's correct, Judge.
Good morning, Ms. Mack. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can put your hand down. Ms. Mitchell?
The state's plea recommendation is going to be a time served, credit for time served 16 days, balance suspended, a stay away from the USPS on 575 Far Road, Atlanta. Nothing further, Your Honor.
Mr. Finley?
Yes, Your Honor. That is our understanding of the recommendation, of which we do agree. And we do stipulate to the factual basis, venue, and ID, Judge.
Ms. Mack, it's my understanding that you wish to plead guilty to criminal trespass and damage to property. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you've given up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the guilty plea as negotiated, Ms. Mack. Good luck to you, ma'am.
Next, we have position 13, Ms. April Jones.
Another negotiated plea, Mr. Finley?
That's correct, Judge.
Good morning, Ms. Jones. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me, Ms. Jones? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Put your hand down. Thank you, ma'am. Ms. Mitchell?
Yes, Your Honor, this will be a time served plea, credit for time served 16 days, balance suspended, a stay away from MARTA. Nothing further, Your Honor.
Finley?
Yes, Judge. That is our understanding. We do agree to the state's recommendation and additionally stipulate that the factual basis, venue, and ID.
Ms. Jones, it's my understanding that you wish to plead guilty to reckless conduct and criminal trespass. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept your guilty plea as negotiated, Ms. Jones. Good luck to you, ma'am.
All right, thank you.
You're welcome.
Thank you, Your Honor. Have a wonderful morning.
Okay, I'll see you this afternoon.
Yes, sir. No.
No? Okay, well, I'll see you next time.
All right.
Who do we have now?
Your Honor, position number 20, Mr. Middleton, position number 20.
And this will be a bond hearing this morning, Judge?
And he needs to be arraigned also, correct?
That's correct.
Good morning, Mr. Middleton. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Sure.
Thank you. Can you raise your right hand for me, sir? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Middleton. You've been charged in case 20 CR 000377J with simple battery family violence. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation?
Yes, Your Honor.
How do you plead to this charge, Mr. Middleton? Guilty or not guilty?
Not guilty.
We'll record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. Ms. Harrison, can you tell me the history, please?
Yeah, I don't have a file on this defendant. I apologize.
Mr. Segura, do you know his history?
I noticed some parts of his history, and he has some crime originated from Alabama. In 2011, he had a domestic violence in the third degree and harassment in 2013. In 2020, he was arrested for simple battery, family violence. In 2020, he was arrested for aggravated assault, and in 2021 for battery.
Okay. And the date of the simple battery that we're here for is in 2019, is that correct?
Yes, the August 22nd, 2019.
What's his current bond?
I'm uncertain for his current bond. I could check.
Judge, when I checked on Odyssey, I didn't actually see a bond associated with this simple battery. Or actually, Judge, it's the total bond. They just have it referenced as a total bond of $14,000.
Is he out on bond in the other cases?
I don't believe so, Judge, no.
So do we know whether or not the other cases were in Fulton County or were they someplace else? All right, so you all aren't making it easy for me to decide on a bond here.
Judge, I don't have any record of where those other two charges took place. I just see them on the Fulton County booking screen. If the state could give more.
Your client has his hand up, Ms. Helen.
Yes, Mr. Middleton.
I'm on felony probation. I caught that last year to first offender 5-year probation on the felony. I have for the aggravated assault, and this case right here was booked when I was locked up on this case right here before I copped out to the aggravated assault. This case was over my head. And when they gave me a signature bond the last time and I copped out to this case, the jail automatically let me go because I had a different lawyer on this case and he told me to stay a week later. He was going to give me time served on this case, but I couldn't stop the jail from releasing me because they reinstated my signature bond.
Your Honor, it appears that case number is 20SC174401. He was sentenced January of 2021, 1 year confinement and 4 years probation. It is first offenders.
All right, so this case that we're here for allegedly occurred before that, and that's in 2019. And it does not appear that he has a bond on it. Do we know the alleged victim's name, Mr. Segura?
Her name is Kia Daniels. Kia spelled K-I-Y-A, Daniels common spelling.
Has your office spoken with Ms. Daniels?
I believe we have. And she said she wasn't injured and had no visible injuries, but at the same time, we do have photos that were uploaded that show some of the dull injury to a property.
Okay. Do you have a resident address?
Let me check. It should be at 1737 McClelland, spelled M-C-C-L-E-L-L-A-N-D Avenue, apartment 14, East Point, Georgia.
All right, so take down the bond, Ms. Helen. Let me know when you're ready.
Yes, Your Honor.
A $5,000 SOB through the jail. No further contact with Kia Daniels. Stay away from the 1735 McClelland Avenue, apartment 14 address. No drugs, alcohol, or weapons while out on bond.
Mr. Middleton, did you just hear the judge? He's
Yes,
giving you the
ma'am.
5,000 SOB on this charge.
Yes, ma'am. I appreciate it.
Okay.
Thank you very much.
All right, good luck to you, Mr. Middleton.
Thank you.
Thank you, Your Honor. And I'll submit that modification to, I believe it's Miss Lewis today or Miss Middlebrooks.
Yeah, and I'm gonna appreciate my mother for showing up. Tell her thanks.
Thank you, Mr. Middleton.
Next, we have position 28, Mr. Turner.
This is a non-negotiated plea, is that correct?
That's correct, Your Honor.
Good morning, Mr. Turner. I'm Judge Eric Morrow. This is the state all-purpose calendar. We are conducting this calendar by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, sir? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Do you have his history, Ms. Harrison?
No, Judge.
Okay. Mr. Segura?
Check. I have it as 32 total cycles. They're mostly drug possession charges.
Proceed, Mr. Segura.
For our negotiated plea, a non-negotiated plea, the state is asking for 12 months to serve 60 days, credit for time served 14 days, balance probated, FVIP, 80 hours community service. A stay away for the instant location located at 4300 Flat Shores Road, apartment 3909, Union City, and no further contact with Kay Turner and Kristen Turner. We base these recommendations are mostly on the facts, which was when the defendant knocked on Kay Turner's front door, and once inside, he told her that he was, quote, "I was going to kill him." Ms. Turner asked the defendant, who is her ex-husband, that he only says this sort of stuff when he is high of some sort of drug. When she told the defendant to leave, the defendant saw him take his clothes off and said he was going to sleep. Then Turner told him he had to go, but Kay Turner then called her daughter to help her, who was with her granddaughters in another room. Kristen heard her mother say, "Help me," and then went up to help her mom. She saw her mom asking the defendant to leave, and the defendant was pushing her back, screaming, saying, "You're going to kill me." Then they called 911, and they both tussled with the defendant to get him outside. The defendant kept pushing Kay Turner as she tried to push the defendant outside the front door. When they told the defendant they called the police, they locked the door. They kicked in the door, popped it off its hinges, and got in. Then Kristen Turner tried to block the defendant from entering because she feared for a murder. The defendant tackled Kristen to the ground, and then the police arrived. We got notification that the victim indicated that she no longer wants to be contacted, but we are concerned about her safety because of his history of drugs and also getting kind of violent with drugs. As such, that is our recommendations. Thank you.
What is the false information?
Can you repeat that?
He's also charged with giving false information to law enforcement. What false information did he give to law enforcement?
I believe the police report did not specifically say what was the false information.
I'm sorry, Mr. Sewer. Say it again.
When I was reading the police report, it did not indicate what exactly was the false information. But then it was related possibly to his name.
Okay. Ms. Helen?
Yes, Judge, this is a non-negotiated plea. What I have on record is that there are 2 FTAs in this case, that Mr. Turner didn't have new charges to which got him arrested for this. There were 2 FTAs in November 4th, 2021 with Judge Edie for a jury trial, and then in December 14th in 2021 with the same judge. He had no notice of these FTAs. They had an old address of 1839 Sneer Burns Circle, Riverdale, Georgia, 30296. I have a current updated address of 1781 Childress Drive, Southwest Atlanta, 30211, which is his father's address. And so, Judge, we are asking for time served in this case. I believe with the state's recommendation, it will be 12 additional days. We're just asking for this to be time served again because these weren't new charges. These were failing to appear, but we have an updated address. Mr. Turner would like to resolve this case. And he understands that there is no contact with Ms. Kay Turner or Christian Turner, and he hasn't had any contact with them since this case 4 years ago. That's 2017. He has kept his distance from those individuals. And I do believe he shares the daughter, Kristen, with Ms. Turner. And he still has maintained to stay away from them. So, Judge, we're asking for time served on this. It's actually credit for 18 days. Mr. Turner did 6 days in 2017, from November 28th to December 13th. So I have a credit for time served, 18 days.
And he has no, as far as the remainder of the recommendations, Ms. Helen, he has no problem with those?
No, Your Honor. Again, he wants to resolve this case. He understands the seriousness of these charges, but we would ask for it to be time served.
All right. Anything further, Mr. Segura?
And none for me.
Mr. Turner.
I'm sorry, Judge, sorry to even cut you off, but if the state does not have a problem, can Mr. Turner use his NOLO for this case?
We have no issue with that.
I have a history if you would like to hear it.
Oh, okay. Thank you, Ms. Harrison. Go ahead.
32 cycles. Last arrest was March of, oh, I'm sorry, that's the current charge. Last arrest was November of 2017 in Union City, and that was a possession of controlled substance, Schedule 1, no disposition listed. Last conviction I'm showing was a 2013 Cobb DUI arrest.
Okay. Thank you, Ms. Harrison. Mr. Turner, it's my understanding that you wish to plead guilty to 2 counts of battery, family violence, and giving false information to law enforcement officers. Is that correct? No, you like to plead NOLO to those charges. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading NOLO to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead NOLO?
No, sir.
I'll accept your NOLO plea, Mr. Turner. The sentences will be 12 months to serve, 36 days. Credit for time served, 18 days. Balance probated, a family violence intervention program, 80 hours of community service. Stay away from the 4300 Flat Shoals Road, Apartment 3909 address, and no further contact with Kay Turner and Kristen Turner.
Yes,
I am going to waive the probation fees while you're out on probation to help you get and stay on your feet. And you're going to have to be on probation for the entire time, but I'll waive the fees. And it's my understanding that you're going to have to report on April 1st, 2022 to the probation, which is in the chat. And you'll get that information. Anything further on Mr. Turner?
No, Your Honor.
All right, good luck to you, Mr. Turner. Mr. Murphy, did you have any additional business with the court this morning?
Judge, I was advised by the PD that Jeffrey Alexander Cash is on the calendar.
Is that your client?
It is, Judge. It's an appointed case from July of last year. And I was hoping I could go to breakout room with the state.
Okay. Mr. Cash is position 6 on the calendar, and that is Mr. Finley's case. So, Mr. Finley, if you want to go into a breakout room with Mr. Murphy, we'll take someone that's Ms. Helen's case.
That's Mr. Cash is a conflict case. That's what Mr. Murphy's.
Apparently, that's what Mr. Murphy's telling me.
Yes.
So, do you have any problem going into a breakout room and speaking about this case, Mr. Finley?
No problem. No problem, sir.
Okay. So, Ms. Lewis, if we can put Mr. Finley and Mr. Murphy into a breakout room, and courtroom 2, if we can go to one of Ms. Helen's cases, which are positions 18 through 33.
Okay, thank you.
Okay.
Excuse me, Judge, did you want the solicitor?
Yeah, sorry, that was I was a little bit confused about. Yeah.
I'm sorry, Mr. Finley.
No, you're good. I was like, I'll go into a breakout room. Sorry, I was a little bit confused.
It's been one of those days.
No worries.
Whose case is this? Mr. Segura? Ms. Mitchell?
Yes, it's mine, Your Honor.
All right, so Ms. Mitchell, would you go into a breakout room?
Your Honor, can I be included on that breakout room as well, please?
Of course. Good morning, Mr. Walker.
Good morning, thank you.
I'm sorry for confusing you, Mr. Finley. That's totally
No worries, no worries. Thank you, Judge.
Okay, so let's see. Who do we have in courtroom 2?
Position 31, Mr. Wilcox.
Is that your case, Mr. Segura?
Wilcox, it is.
Okay, good. All right. This is a negotiated plea.
That's correct, Judge.
Good morning, Mr. Wilcox. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? You're on mute, courtroom 2.
Go ahead, Mr. Wilcox.
Yes, sir.
All right. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down, sir. Thank you. Mr. Segura?
The plea is 12 months to serve 34 days, credit for time served 17 days, balance suspended, and a stay away from the Chevron Food Mart at 923 Lee Street Southwest.
Yes, Your Honor, that is our understanding of the recommendation. We stipulate to the factual basis, venue, and ID.
Mr. Wilcox, it's my understanding that you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
No.
Yes?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the guilty plea as negotiated, Mr. Wilcox. Good luck to you, sir.
All right, next we got number 16 and 17, Mr. Mahan.
Your Honor, I'm 18 through 33.
Okay, well, we have Mr. Finley with us
Oh,
now.
yeah, that's right.
Your Honor, I believe positions 1 to 17 is Ms. Mitchell's.
Okay. So which cases are yours, Mr. Segura?
18 and below.
All right, so can we get someone that's 18 and below, courtroom 2?
Position 25, Mr. McCuller.
I have position 25 as Mr. Shannon.
Lorenza Shannon.
Okay, let's switch out. Russian, come on, Russian. Mr. Russian, position 24.
Okay. This is going to be an arraignment.
No, Your Honor, this is going to be a negotiated plea. I spoke to Mr. Russian. We will be entering a negotiated plea on his behalf today.
Okay. Good morning, Mr. Russian. I'm Judge, I'm sorry. Are you settled there, Mr. Russian?
Yes, sir.
Okay, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand to the best of your ability for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You put your hand down. Thank you, Mr. Russian. Mr. Segura?
The plea is 12 months to serve 50 days, credit for time served 16 days, balance probated, no further contact with Cassandra Smith, 8 weeks anger management, and 60 hours community service.
Yes, Judge, that is our understanding of the state's recommendation. We agree with that recommendation, and we stipulate to the factual basis, venue, and ID.
All right, Mr. Russian, it's my understanding that you wish to plead guilty to battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you've given up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your guilty plea as negotiated, Mr. Russian. Good luck to you, sir. I'm gonna waive your probation fees while you're on probation to help you stay on your feet, okay? And
All right.
All right, so good luck to you, Mr.
Thank
Russian.
you, sir.
Oh, we got a record.
All right,
Thank you, Judge.
All right, going back to 16 and 17.
These are gonna be arraignment. It's gonna be an arraignment.
That's correct, Judge.
Okay. Do we have the bond orders on Mr. Megan? 16 and 17. Thank you.
Hey, Judge, could we let Mr. Russian know that he has to report to 132 Mitchell Street? I just wanted to let him know before he walks past.
He already wrote it down.
Oh, okay, thank you so much, Deputy.
You're welcome.
And we're waiting for Mr. Mahan.
Right here.
Oh, I'm sorry. I thought that he was in courtroom too. I apologize. Good morning, Mr. Mahan. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, you can put your hand down. Yeah. Mr. Mahan, you've been charged in case 22 CR 001258A with simple battery, family violence, and in case 22 CR 001259A with simple battery, family violence. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusations, Mr. Finley?
I do, Judge.
How do you plead to these charges, Mr. Mahan? Guilty or not guilty? Say it louder for me. Not guilty? Okay, you're gonna have to scooch. I can't hear you, Mr. Mahan.
Guilty.
Okay. Mr. Finley? It's my understanding that he said guilty.
Mr. Mahan, is that, you want to plead guilty?
Yes, sir.
All
right, I'm gonna need to speak with him, Judge.
Okay, so you'll need to go into a breakout room then, Mr. Finley.
Yes, Your Honor.
All right, let's see. Courtroom 2, Mr. Finley, so positions 1 through 17. Do we have anybody below 17 that we can go to?
In the chair in front of you, Your Honor, we have Mr. Terry, Trevion Terry, position 27.
Okay, very good. And this is a non-negotiated plea.
That's correct, Judge.
Good morning, Mr. Terry. I'm Judge Eric Morrow.
Good morning.
This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yeah.
Thank you. You've been, can you raise your right hand for me?
Yeah.
You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yeah.
Okay, you can put your hand down. Thank you. Let's see, Mr. Segura.
The plea deal on our end will be 12 months to serve 40 days, credit for time served 16 days, ban suspended, a stay away from the mortar at the 2424 Piedmont Road and all other mortar locations, and an MHET. Our recommendation is mostly based on the facts, which was that the defendant interfered with mortar service by wrapping a belt around the door handle, preventing any mortar patrons or employees from entering the elevator while the defendant slept on the floor. At this, I think we need a breakout room because one of the charges is an indecent exposure. But I can try to dance around it. This individual was naked while on the floor and basically visible to anyone who saw it in the parking deck of City Market Center. And the defendant had a mortar suspending him until November the 9th, 2021. And this incident was on 2 months beforehand, at September. And he was told several times that he was sleeping, that he was supposed to leave, but he did not. Thank you.
Yes, Judge, this is a non-negotiated plea. I am asking for a recommendation of time served, balance suspended, specifically time served, because if you look at the date, Mr. Terry here is for 2 FTAs in this case. With Judge J. Roth from December 22nd, 2021 for a plea and arraignment, and then a January 10th of 2022 with Judge Law. I'm also asking for balance suspended because when I spoke to Mr. Terry, he was residentially challenged. This is not a situation of an individual needing MHET. He was residentially challenged. And as you heard ASG Segura mention, he was holding the door to get shelter. If you look at the court date, September 14th, he's just looking for warm shelter. That is why I'm asking for time served. This was not violent. It was not violent towards anyone on MARTA or with MARTA employment. I'm asking for balance suspended. When I talked to Mr. Terry, there were no mental health issues present, Your Honor. This was an unfortunate incident of someone being residentially challenged. Again, he was not violent towards anyone. In fact, when I spoke to him, he was speaking to MARTA to determine if there was a suspension so that he could follow along through it. Judge, I would just ask if there could be, if you're not amenable to remove the stay away completely from MARTA, just to adhere to any active suspensions if there are. Again, Judge, we're asking for time served. This was not a violent incident. I do understand the charge of public indecency, but he was residentially challenged. And then also for the balance suspended, we are just asking that if you do adhere to the MARTA, that it just be to any current suspensions, Judge.
Do you have his history, Ms. Harrison?
Yes, Judge.
Okay. Are you ready?
I'm showing, just a moment. Ugh. I'm showing history in Mississippi, Florida, and Georgia. 15 cycles out of Georgia. I'm showing a December 2021 probation violation, a 2021 conviction in DeKalb County for theft by shoplifting, misdemeanor. That's two arrests in 2021 for theft by shoplifting. The other is in Dunwoody. Failure to appear, April of 2021. Another conviction for theft by shoplifting, also in 2021. Another theft by shoplifting in 2021. And 2013, another theft by shoplifting. Nothing further, Your Honor.
Okay. Anything further, Mr. Segura or Ms. Helen?
No, Judge, I just want to emphasize that this is not a violent or career criminal, and that we are asking for time served, balance suspended.
Mr. Segura, anything further?
None on my end.
Okay. Mr. Terry, it's my understanding that you wish to plead guilty to criminal trespass, certain acts on a bus rail station prohibited, and a third misdemeanor offense. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No, and I was also explaining to her at the time, I had a little irritation between my legs, so that's why they had put something about public decency right here. But I immediately spoke with the MARTA staff, and so I was able to.
Hold on for me there. I guess my question, if you'll just answer the questions that I posed to you, Mr. Terry, okay?
Yeah.
And I think my last question was, are you under the influence of any drugs or alcohol this morning?
Oh, no.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anybody forced or coerced you to plead guilty?
No.
Okay. I'm going to accept your guilty plea, Mr. Terry. The sentence is going to be 12 months to serve 32 days, credit for time served 16 days, balance suspended, and you're to stay away from any active suspensions from MARTA. So if MARTA has an active suspension on you, then you can't go back there. If they don't, then you can go back there.
Okay.
The problem's going to be that if they have an active suspension and you go back there, then you're going to be in violation. Okay, so it's up to you to make sure that you're allowed to go back to MARTA. You understand?
Yes, I understand.
All right. Good luck to you.
Okay, thank you.
Thank you so much, Judge.
We're going back to 16 and 17.
Okay, did we work that out, Mr. Finley?
Yes, we did, Judge.
And what are we doing this morning?
This is going to be a negotiated plea, Judge.
Okay. Let's see. This is your case, Ms. Mitchell?
Yes, Your Honor.
Okay. Whenever you're ready.
Okay, so this is gonna be a consolidated plea, position 16 and 17. The plea recommendation is gonna be 12 months to serve, 32 days confinement, credit for time served 16 days, balance probated, no further contact with Jasmine Bryant, a stay away from 443 Ponce de Leon Avenue Northeast, Atlanta, FVIP course, and 80 hours community service in alcohol, drugs, and weapons. Nothing further, Your Honor.
Mr. Finley?
Yes, Judge. We would just ask that the probation fees be waived, and also that once Mr. Mahan does complete the FVIP course and the community service, if he could be non-reporting, Judge.
Do we have his history, Ms. Harrison?
Yes, Judge. 19 cycles. Last arrest was September of 2019 for probation violation in Fulton County. Underlying charge was aggravated assault. Record does indicate the defendant is currently on probation in Fulton County for theft by receiving stolen property. 15 SC 134894, sentenced April of 2016, 9 years probation. Also a 2018 misdemeanor conviction for battery, cruel to the children, 3rd degree, and an additional battery in 2014, family violence, in which he pled a nolo. He has a 2013 felony conviction for aggravated battery, failure to appear, and 4 violations of probation. Nothing further.
I'll waive his fees, Mr. Finley, but he'll have to be on probation the entire 12 months.
Understood, Judge.
Okay. And Mr. Mahan, it's my understanding that you wish to plead guilty to 2 counts of simple battery family violence. Is that correct?
Yes, sir.
Okay. Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with this representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the guilty pleas as negotiated, Mr. Mahan. I'm going to waive your probation fees while you're on probation to help you get and stay on your feet. But you're going to have to be on probation for the entire 12 months, okay?
Yes, sir.
All right. Good luck to you, Mr. Mahan.
Thank you, sir.
Who do we have next?
Judge,
Yes. Yes, Mr. Murphy.
on Jeffrey Allen Cash, Your Honor, if we could reset it to next week on the 29th, he's in there on felony charges, and I got to speak to his felony attorneys and then see him at the jail before we can try to resolve it.
Okay, that's fine. We'll reset them to next Tuesday, 3/29.
Duly noted. Thank you, Your Honor.
Thank you. Courtroom 2.
We got position number 19, Mr. McQuillan.
This is a negotiated plea.
That is correct, Judge.
Good morning, Mr. Quiller. I'm Judge Eric Morrow. This is a state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down, sir. Thank you. Mr. Segura?
We're asking 12 months to serve, 216 days, credit for time served, 108 days, ban suspended, and a stay away from Malta at the 641 West Peachtree Street, Atlanta address.
Yes, Judge, that is our understanding of the recommendation, and we agree with the state's recommendation, and we stipulate to the factual basis, venue, and ID.
Mr. McQuiller, it's my understanding that you wish to plead guilty to criminal trespass and obstruction of a law enforcement officer. Is that correct? You're on mute, courtroom 2. My question was, Mr. McQuiller, that's my understanding that you wish to plead guilty to criminal trespass and obstruction of a law enforcement officer. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation? Her representation? You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anybody forced or coerced you to plead guilty?
No, sir.
All right, I'll accept your guilty plea as negotiated, Ms. McCullough. Good luck to you, sir.
Thank you, Judge.
Clifton, come on. Come on. We have position number 33, Mr. Clifton Williams.
And this is non-negotiated.
That's correct, Judge.
Good morning, Mr. Williams. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Can you raise your right hand for me, Mr. Williams? Do you swear and affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Thank you, sir. Mr. Segura.
Our plea is 12 months to serve 90 days, credit for time served 15 days, balance probated, and a stay away from the Raheem and Variety Store, located at 4485 Camberton Road, Southwest Atlanta. We're basing this plea based mostly on the facts as well as its history. As for the facts, the defendant was the property of the Sherwin Food Mart trespassing. The owner of the property, Udin Akbar, said that he has had multiple problems with the defendant in the past and would tell him to leave, but he wouldn't. The defendant would go to the area and harass customers, and has done so on several previous occasions. Police officers have warned the defendant about not trespassing on his areas, but he has not listened, and is actually arrested for trespassing on a Shell station next door. And business owners and general employees in the areas had negative interactions with the defendant and always want him off their property. And in this case, there was a seafood place, the Raheem store, that was connected to the Sherwin Food Mart, and he was again harassing people. And at that time is when he was arrested. Part of our plea deal is mostly based on his history, and there's a really good chance that he will reoffend. Namely, he has history originating from Florida for criminal trespassing, dating from at least twice in 2016, twice in 2017, and as well in Georgia, around 3 times in 2012, once in 2013, once in 2014, as well as once 2018 and 19, and earlier in January. Based on his history, there's a good chance he'll reoffend, and that's why our plea deal is what it is. Thank you.
Yes, Judge, this is a non-negotiated plea. I do understand, at least hear the history from ASG Segura. However, with the state's recommendation, Mr. Williams would do 30 additional jail days on top of the 15 days of incarceration he's done. I believe that's very extreme for a criminal trespass. When I spoke to Mr. Williams, he understood that he cannot go back to Raheem and Variety. He understood that's 2 football fields from that location. And Judge, Mr. Williams is nomadic in a sense. I do not believe that there will be another criminal trespass from that, but I do understand that those are in his history. We are asking Judge essentially for time served and a balance suspended for Mr. Williams. I do believe the 15 days that he has done of incarceration is satisfactory for this, but he understands there is a stay away of 2 football fields from Raheem Variety at 4485 Campbellton Road, Judge.
Ms. Harrison, could I hear the dates of, could I hear the history from you, please?
Your Honor, I'm showing 75 cycles with 41 in Florida and 34 in Georgia. Also, there's an arrest in 2019 for a CWAC charge, and that was by MARTA PD. He was sentenced. In addition to that, it was a criminal attempt to commit a felony and theft by take-in. And in 2019, disorderly conduct, in which he pled a NOLO, a 2018 simple battery, 2018 criminal trespass, MARTA, probation violation in 2017, criminal trespass conviction 2014, 2014 additional criminal trespass conviction. And probation violation in 2014. Additional criminal trespass conviction, 2013.
Okay.
2012, I'm sorry, go ahead.
No, thank you, Ms. Harrison. I appreciate it. Ms. Helen, does he have a place to live?
Judge, I do have an address of 4220 Notting Hill Drive, Atlanta, Georgia. I also have an opportunity for Mr. Williams possibly to have housing through the Grady Hospital through a program as well. But I do have a permanent address as well as another program that Mr. Williams is a part of.
What type of program is he a part of?
It's a mental health, it's MHC, the mental health court being offered through Grady Hospital. So we're in the process of making a referral for Mr. Williams, which I do believe includes residential housing as well as medication, Judge. But I do have a permanent mailing address of 4220 Notting Hill Drive, Atlanta, Georgia, 30331.
Your client has his hand up, Ms. Helen?
Yes, Mr. Williams. If you have a question about procedure, or you can give me a call and we can talk about it, but otherwise, we should definitely try to move through here. Do you have a procedure question?
I just wanted to know, I had a warrant out for another trespass. I just want to handle both of them today.
Oh, good question, Mr. Williams.
Shells, remember he said the shells? I had one January the 28th.
Well, Judge, Mr. Williams, give me 1 second. I'll tell the judge, okay, Mr. Williams? Mr. Williams informed me he believed that there was an open case somewhere else earlier in January. If ASG Segura or pretrial services could see if that's possible. I didn't see any open case from January, but he did have a question about that. January of this year, 2022.
Mostly in the police report, it mostly noted that he was arrested on criminal trespassing on that January, and he was mostly told beforehand about that. Can you see if I can find it? Yeah, the police report, it says, this is Mr. Williams' second arrest this year for criminal trespassing in the same general area where he is warned almost daily not to be on properties.
Well, Judge, we were just asking, we just wanted to make sure that some other case or charge wasn't holding him. I didn't see another case other than my own, but just want to make sure nothing else is holding him.
So, Mr. Segura, is this an active case?
Let me check. From what I see, this is his only thing that's holding him.
All right.
Did you hear that, Mr. Williams? My case is the only case that's holding you, okay? I think they're muted, but okay.
So, Ms. Helen, my inclination is that something's going on with Mr. Williams, and although I am willing to give him a time served, I'm also not willing to just put him back out on the street. As such, I would be ordering that he be on probation, go to the Grady mental health, get a mental health evaluation and treatment through that through the Grady program, and that he be on probation while he is receiving mental health evaluation and treatment. Once he's received that, if he does that within the 12 months, then it'll go to a non-reporting status.
Understood, Judge.
Is he agreeable to that?
Mr. Williams, the judge is going to give you time served. However, he's going to require you to do a mental health and evaluation, okay? As well as the stay away from Raheem and Variety at 4485 Campbellton Road, and you will report to probation.
Oh, I got to report 72 hours, right?
We're about to, if we can get the location and the date, they're going to give you a date to report. They do it differently, okay?
Everything is in the chat.
Okay.
So,
All right.
Yep, and Mr. Williams, they want you to report to 132 Mitchell Street, Southwest Suite 2A with Officer Harris at 1:30 p.m. on April 1st. I think they're gonna help you write it down too.
All right.
April 1st.
He's amenable to the plea.
Yes, Judge. Thank you.
All right, so,
See right here? See that one?
To who? All right.
Next, we have position 5, Mr. Burris.
I haven't taken Mr. Williams's plea yet.
Oh, I'm sorry.
That's all right.
I was just walking back in.
That's not, no problem. It's one of those days for me.
All righty.
Okay, so let's see, Mr. Williams, it's my understanding that you wish to plead guilty to criminal trespass. Is that correct?
That's right, Your Honor.
Are you under the influence of any drugs or alcohol today?
No, Your Honor.
You've been represented by counsel. Are you satisfied with her representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anybody forced you or coerced you to plead guilty?
No, Your Honor.
All right, I'll accept your guilty plea, Mr. Williams. The sentence is going to be 12 months to serve 30 days, credit for time served 15 days, the balance probated. You are to have a mental health evaluation and treatment if necessary through Grady. You're to stay away from Raheem's and Variety Store at 4485 Campbellton Road. And I am going to waive the probation fees while you're on probation. As soon as you complete the mental health evaluation and treatment, if necessary, then the probation will go to a non-reporting status. Okay, Mr. Williams?
Yes, Your Honor.
All right, good luck to you, sir.
All right, thank you.
Next,
Thank
we
you,
got
Judge.
29 and 30, Mr. Walker.
Okay. This is negotiated pleas.
Yes, Judge.
Good morning, Mr. Walker. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, put your hand down, Mr. Walker. Thank you. Mr. Segura?
For 29, the plea is 12 months to serve, credit for time served 248 days, balance probated, FWIP. I stay away from 921 West Moreland Circuit, apartment 2104, Atlanta, and no further contact with Olivia Marks. For position 30, it will be 12 months to serve concurrently, credit for time served 248 days, balance probated, FWIP. I stay away from 3132 Desert Drive, apartment 4, East Point, and no further contact with Alicia Darby. Thank you.
Okay. Your client has his hand up, Ms. Helen.
Yes, Mr. Walker, if you have a procedural question, definitely go ahead and give me a call. But if it's just about, what's your question?
Just basically trying to see if I'm gonna be able to visit my kids or not.
Oh, we'll get to that. I'm going to ask for that for you, okay? But we'll get to that. That's a good point. Thank you, Mr. Walker.
Thank you.
Okay, Ms. Helen, go ahead.
Yes, Judge, it is a negotiated plea. However, I have that for 29 and 30, it's two separate people. There's a no contact with Olivia Marks, and then there's a no contact with Alicia Darby. He has no issue with the with the no contact with those individuals, but he has a child with each one of those individuals that he would like to see, and he would like to have third-party visitation, if that can be added to the negotiated plea, Your Honor.
Of course, I would not keep a father from his children, so He can have third-party contact with his children for visitation. Anything further, Ms. Helen?
No, Your Honor.
Okay. Mr. Walker, it's my understanding that you wish to plead guilty to simple battery, simple battery, family violence, and criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept the plea as negotiated. I am going to waive the probation fees while you're out on probation to help you get and stay on your feet. You also have visitation with your children, but it will have to be arranged through a third party. Okay?
Yes, sir.
And it's my understanding that Mr. Walker is in custody on some other charges and that he's not going to be getting out. So I just want the probation to know that, because he won't be reporting given that he'll be in custody, correct?
Correct. If he's able to bond out, and in this case, we'll have probation. So I'd want him to know.
What's the other charge?
Say it again, Mr. Walker.
What's the other charge that y'all saying I need to bond out on? What charge is that?
It's a battery, family violence.
Oh.
So did he want to be reset to handle all of his cases? Or, I mean, I understand he just took a plea on 2 of them, but do we want to reset him for next week if he wants to entertain a plea?
I don't think so. I believe Mr. Walker wants to resolve both of these cases, 29 and position 30 today.
I'm saying, but does he want to be reset for next week for his outstanding case that he's being held on?
Oh, for the new case next week.
It's an older case. It's an older case. It's a 21 CR case.
Mr. Walker, would you like to have that other case that's holding you scheduled for next week, SAP?
Would that stop me from entering my plea today?
No, we're just going to schedule it, and I'll see you again for next week.
Okay, that's cool.
Okay, Judge.
Okay, so we'll put the other charge on next week's SAP calendar. So I'll see you again next week, Mr. Walker.
All right, thank you.
All right. I mean, I hate to see someone sit in jail for 1 more week. So, I mean, if you all know that ahead of time, you might want to alert someone so that we can do them all at once. Just for his benefit. Okay, who do we have next?
Next, we have position 5, Mr. Burris.
And this is going to be an arraignment and a bond hearing.
That's correct, Judge.
Good morning, Mr. Burris. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir. Good morning, everybody.
Let's see. Can you raise your right hand for me, Mr. Burris? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Burris. You've been charged in case 19 CR 004727F with driving while license suspended or revoked, willful obstruction of a law enforcement officer, and violation of a handicap parking. Each of these offenses carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. You waive formal reading of the accusations, Mr. Finley?
I do, Judge.
How do you plead to these charges, Mr. Burris? Guilty or not guilty?
Not guilty.
We'll record your not guilty plea and your case will be returned to the division judge and you'll get notification of your next hearing date. What are the current bonds?
Your Honor, there's a $5,000 cash bond on this case. The defendant originally had a 2,500 signature bond, and then he failed to appear, and then it was changed to a 5,000 surety bond, and then he felt FTA'd again, and now it's a $5,000 cash bond.
Your Honor, I wasn't received any notice.
Mr. Burris, I'm gonna make sure to address those issues that we talked about.
So, Your Honor, in this case, the defendant was seen parked in a handicapped parking space.
Give me 1 second, Ms. Mitchell. I'm sorry.
Okay. Yes, Your Honor.
I just see the whole bond. Okay, I'm sorry, Ms. Mitchell, go ahead.
The defendant was seen parked in a handicapped parking space by an officer. When stopped, the defendant failed to provide a valid license and declined to give his name and birth date. The defendant was driving the vehicle of another person. The handicap placard used also belonged to the owner of that vehicle, not the defendant. During the traffic stop, the defendant started the vehicle and fled. Investigators later found out the defendant was driving on a suspended license out of Louisiana and is unlicensed in Georgia. The defendant also had multiple active warrants out of Clayton County and DeKalb County at that time. As already stated, the defendant FTA'd on this case twice. The defendant is also a convicted felon. It appears that there's a current outstanding warrant that was issued on October 4th of last year for probation violation out of Jonesboro. On that warrant, it's noted that the defendant is armed and dangerous with violent tendencies and drug abuse, and that he's also an escape risk. Including the FTAs on this case, the defendant has 8 failure to appears. He also has 1 fleeing in 2019. And he was also convicted of fleeing in 2019. So there's 2 separate fleeings. He's convicted of driving without a valid license in 2019, driving without a suspended license in 2019, and then again, driving without a valid license in 2015. So this is not his first time receiving these charges. And so that's going to be, our recommendation is that the bond remains the same, Your Honor.
And if you were to take a plea, you've got 120 days to serve.
Yes, Your Honor.
All right, Mr. Finley.
Yes, Judge. And while I do recognize the history and concerns that Ms. ASG Mitchell just read, I did review with Mr. Burris, obviously these FTAs and the importance of respecting the legal process in that way and returning to court. I can only speak to the recent FTAs in which he said he changed addresses. He did not receive notice. He stated that if he did receive notice, he certainly would have been to court, and he was very empathetic to the fact that he did miss court. And I really stressed to him the importance of his return to court. Money is an ongoing issue in Mr. Burris's life. He did have back surgery, a spinal fusion, which has left him unable to work. So as we heard, he does have a $5,000 cash bond right now, which he cannot come even close to making. That $5,000 cash bond is effectively a no bond because he just has 0% chance of being able to afford that. So we are asking for a $2,000 surety bond for Mr. Burris, and I hope that after my conversations with him yesterday, he will make sure the address is correct. He did give me a 2845 Jerome Road in Atlanta. So I really hope after our conversation yesterday, he obviously returns to court, changes his ways, and I believe he will.
Okay, and tell me again, Mr. Finley, what's the good address that he gave you?
Yes, Judge. It's a 2845 Jerome Road. That's J as in John, EROME Road, Atlanta, 30349.
Okay, so that address that you just listed, I am looking at a letter that was mailed out by the State Court of Fulton County. It was filed on January 18th of 2022. The address given was the address listed was 2845 Jerome Road. And it was returned to the court saying return to sender, not deliverable, as address unable to forward. So it appears that he is giving you an improper address also. And we still don't have a proper address.
Understood, Judge. That is the address.
Okay.
Was given.
That's the problem, Mr. Finley.
Yes, sir. I completely understood. Completely understood.
All right. So I'm not inclined to change the bond at this point in time. given that he's been
That is,
given.
that is my address, Judge. I'm sorry. They came pick me up from my house from this address. They came and picked me up out of my residence from this address. Y'all have this. They came, if you look on the sheet, that they came and arrested me. I came to the door. I'm not running. I'm trying to change my life, sir. That's all I'm trying to do is just get this behind me. This is an old charge from 2018, sir. And I just really want to see if I can really like get this resolved really without all that time, sir. Maybe I can get credit for time served if possible.
Mr. Burris, I would advise just let's stick to speaking to trying to get a good address if you state.
Why don't we do this?
Judge, this is my address. I did not lie or nothing because they came, the sheriff's office came and picked me up from my residence. And they told me I had this warrant and I had a warrant.
Mr. Burris.
Hold on for me. Mr. Finley.
Yes, sir.
Why don't we put him on next week's SAP calendar if he can't make the 5,000, and you investigate what he's telling us, because there's obviously some problem if he says that he's living there. If he was picked up from that address, if you will confirm that for us. So something is preventing him from.
Yeah, it's some kind of clerical error, sir, or something like it's human error or something.
Understood. Mr. Burris, I'll see you again and we'll go over this issue and make sure we'll nail down a good address. I understand the concerns of Your Honor.
Okay, all right. So we'll put him back on for next Tuesday if you like.
Understood. Thank you, Judge.
Okay. All right, I'll see you next week, Mr. Burris.
Okay, thank you, sir.
Next, we have position 10, Mr. Hill.
And Your Honor, briefly, if we could double back to Mr. Walker. I'm not sure if PD Helen is still on, but I did look up that open additional case and it looks like that was transferred to the DA's office last August. It won't need to be reset for next week.
Awesome. Okay. I couldn't really figure it out through the Odyssey screen, but thank you, SG.
I don't know if it's awesome that he has a felony case, but
I don't know who that's awesome for.
Well,
but,
awesome for the clarity. Thanks.
Yeah, but nonetheless, we don't need to see him again.
All right. Okay, let's see. Who do we have next?
This is position 10, Mr. Hill.
Good morning, Judge.
And this is going to be an arraignment and a bond hearing. Is that correct, Mr. Finley?
That's correct, Judge.
Good morning, Mr. Hill. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Judge.
Thank you. Can you raise your right hand for me? Do you swear and affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Judge.
Yeah, you can put your hand down. Thank you, Mr. Hill. You've been charged in case 19 CR 0083331J with obstruction of law enforcement officer. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Finley?
I do, Judge.
How do you plead to this charge, Mr. Hill? Guilty or not guilty?
I did, yes, Judge, but after I got.
Okay, hold on, Mr. Hill. What I need from you is whether or not you're going to plead guilty or not guilty.
Yes, I plead guilty.
Say it again?
I plead guilty, Judge.
All right, well, you might want to speak with Mr. Finley because they're recommending 12 months to serve on this, so.
Yeah, Mr. Hill, this was, or I can speak with him, Judge.
All right. Can I speak, Judge?
Yes, Mr. Hill, this was I met with you yesterday and we talked about you wanted to plead not guilty and that we would.
I apologize. I heard that wrong. I'm not guilty. I apologize.
All right, so your case we'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date.
My speak, son, Judge?
Hold on, I'll let you speak with Mr. Finley in a moment. Let me just get through this. What is the current bond?
Your Honor, it's my understanding he's actually not held on this case. There was a $3,000 surety bond, but he was released on this bond on this case April 14th of last year, where he was originally given a $1,500 signature bond and then he FTA'd. But he's actually currently held on other felony charges, including aggravated assault, strangulation, family violence, and another ag assault, family violence, which he was also given a signature bond originally, and then he FTA'd in that case.
In that case, Judge, we will just do an arraignment, Your Honor.
Your client still wants to talk with you, Mr.
Okay.
I wanted to say, at the time I got discharged, I went directly to prison after this, so I was already in prison by the time I had the court date. So I was already.
Understood. Yeah, that's what I have. Yeah, Mr. Hill. So that's what I have down, that when he did get the FTA, he was incarcerated. He wanted to make sure I said that.
So I couldn't report because I was already in Floyd County Prison by the time.
Okay. Once he Mr. Finley, once he deals with those felony charges, if he bonds out on that, then you can bring him back and we'll reconsider this bond, okay?
Yes, Your Honor. Sounds good.
All right. Good luck to you, Mr. Hill. Who do we have next?
You want to speak to your lawyer?
Yeah, because I was.
Mr. Finley, he wants to speak with you. I don't know if you can call. You want to
Okay. Yeah, I can. I'll call right now.
Well, can you speak with him after court, Mr. Finley, at some point?
Sure. Yeah, I can speak with him.
I apologize, because I'm trying to understand, when I had this FTA, when they gave it to me October, when I got arrested October or something, I went to prison directly after, so I couldn't report to court because I was already incarcerated going.
Okay, Mr. Hill, we're going to give Mr. Finley the opportunity to talk with you in detail after court today, so he'll be in touch with you, okay?
But Mr. Hill, what Judge Morrow said is this case, so this case is not what's holding you. So you just pled not guilty. So this is not what's holding you in, sir.
Yeah, I have a probation violation.
No,
right now.
But I'm gonna come speak with you, okay?
All right.
Thank you, sir.
Next, we have position 18, Erlyn.
25, Mr. Shannon.
Okay, tell me, where are we going? I'm sorry.
Well, 25, Mr. Shannon.
Okay. This is a non-negotiated plea.
That's correct, Judge.
Good morning, Mr. Shannon. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Say that again, sir.
We're doing this by video. Do you agree to have your case heard by video?
Yes, sir.
All right. Can you raise your right hand for me? You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay. Let's see. Mr. Segura?
We're asking for 12 months to serve 108 days, credit for time solved 54 days, balance probated, no further contact with Stephen Tutt, Stephen common spelling Tutt, T-U-T-T, and ADET, and 40 hours community service. Mostly basing this on the facts and his lengthy prison record. As for the facts, the officers respond to a dispute call where the victim, Stephen Tutt, said that the defendant had approached him, grabbed him by his shirt, and pushed him. At the time, it also noted that the defendant was heavily under the influence of alcohol. And when he was asked how much he drank tonight, his response was, quote, "Man, I stayed drinking," end quote. And while to see the jail, the defendant stated multiple times that if he sees Mr. Tutt in the future, he's going to, quote, F him up. He also advised one of the officers that I'll beat your ASS. Alongside, we're looking at his convictions and his criminal. He has 35 total cycles, has multiple instances of simple batteries, as well as aggravated assaults. In 2016, a simple battery, 2018, an aggravated assault, 2009, a family battery, 2010, a simple battery, 2015, a battery, 2016, aggravated assault, 2019, simple battery, as well as a currently in jail in 2021 for aggravated assault. Thank you.
Excuse me, Ms. Helen?
Yes, Judge, can I actually get pre-trial to go over his history again, just with the dates and the charges?
Okay. Ms. Harrison?
34 cycles. Last arrest was June of 2021 for aggravated assault in Fulton County. Record does indicate the defendant has an open case pending for interference with government property, 20 CP 192415. An additional open case for disorderly conduct. Oh, I'm sorry, not that one. That's record indicates the defendant is currently on probation for aggravated assault against law enforcement officers, 16 SC 145144, sentenced February of 2017, 7 years probation. Additional open probation in Fulton County for possession of cocaine, 19 SC 168491, sentenced September of 2019, 4 years probation. Record indicates one failure to appear within the past 10 years, a misdemeanor 2015 conviction for simple battery, and a 2010 willful obstruction of law enforcement officer felony convictions. Nothing further.
Yes, Judge, this is a non-negotiated plea. When I spoke to Mr. Shannon, he did advise me that he is currently on felony probation. He does have an open case. However, Judge, we are asking for time served in this case. Mr. Shannon has done a total of 54 days for this simple battery and disorderly conduct. When I spoke to him, he does not know Mr. Stephen Tutt, has no issues with a stay away from Mr. Tutt 2 football fields, Judge. But we are just asking that this be a balance suspended. Mr. Shannon is advised that this is a very serious case. He understands the seriousness of these charges, but we are asking for time served and the 54 days to be considered time served, as well as balance suspended, Judge.
Given the history, Ms. Helen, I'm more inclined to go along with the state's recommendation on this matter. And in addition to the alcohol, drug evaluation and treatment, there'll be a no drugs, alcohol, or weapons while on probation.
So did you hear that, Mr. Shannon? The judge said, based on your history, that he's going to go with the state's recommendation, which is 1 year probation, no contact with Mr. Stephen Tutt, and alcohol, drug evaluation and treatment, 40 hours of community service. Is that something you would want to take today?
I'm saying I'm already on probation.
Well, wait, Mr. Shannon, if we need to get on the phone and talk, we can, but the judges do that. Okay. Hey, 4 South, can I give him a call real quick? At what?
I'm on probation. I don't need no more probation.
Well, wait, Mr. Shannon. What's the number to 4 South?
That's really is those number on 4 South. You gotta do a breakout session.
Oh, if we could do a breakout, just like 3 minutes, Judge.
Okay, that's fine, Ms. Helen. Ms. Lewis, can we get 4 South and Ms. Helen into a breakout room, please?
Yes, sir.
And we'll go back to courtroom 2 while they're in the breakout room with, if you have a position 1 through 17 in courtroom 2.
Yes, I got position, you said 1 through 17?
Yes, those are Mr. Finley's cases.
Okay, you switch out with him. We're gonna do position 9, Mr. Green.
Okay,
You gotta be in the box, so it's all right.
this is non-negotiated, Mr. Finley.
That's correct, Judge.
Good morning, Mr. Green. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Courtroom 2, he's on mute.
Sorry.
Yes, sir, I do.
Okay, thank you. Can you raise your right hand for me, Mr. Green? You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you put your hand down. Thank you. Ms. Mitchell?
Yes, Your Honor. We're recommending 12 months to serve, 60 days confinement, credit for time served, 12 days, balance probated, 8-week anger management, ADT, a stay away from Grady unless seeking medical treatment, and no alcohol, drugs, and weapons. So, Your Honor, in this case, the defendant, who was a patient at Grady Hospital, tried to bite the security on the scene along with another staff member as they attempted to restrain the defendant for being irate. During the restraint, the defendant threatened to shoot up the hospital. He also specifically threatened to leave and return with a .45 caliber handgun to shoot up the nurse and his family members and other staff members in the presence of the security on scene. The defendant stated that he was under the influence of narcotics at the time, specifically weed with cocaine. This case was transferred from the DA's office June 26 of 2019, and the defendant failed to appear on his plea and arraignment on October 4th of that year. The defendant is also a convicted felon. So, Your Honor, that's going to be the basis of our recommendation. Nothing further.
Excuse me, sir, I was in prison.
Yeah.
Mr.
Green, Mr. Green, I'm going to speak on your behalf right now, sir.
Go ahead, Mr. Finley.
Yes, Your Honor. While I do recognize the seriousness of these allegations are from April 2019. Since April 2019, Mr. Green has been in prison. So as we heard, the state is asking for 60 days confinement, which after the 2-for-1 and factoring in credit for time served would mean he'd be serving 18 additional days in jail. Like I said, Judge, Mr. Green has been in prison since November 24th, 2019. Thereafter, he was immediately taken into custody by Fulton County. So this would mean Mr. Green has been incarcerated for the last 849 days. That is 849 jails that he's been sitting within the four walls of a jail cell to think about the mistakes he has made. So the state, after those 849 days, the state's asking for 18 more days. I'm not too sure, Judge, what an extra 18 days is going to accomplish that the 849 did not. He does have 2 interviews that are set up once he gets out, one with a janitorial service and one with a construction company. He also has a 5-year-old daughter that's awaiting him, who he's missed majority of her life, obviously. So we are asking for him to be able to kickstart his life after that long period of time and begin rebuilding his life, Judge. And that, once again, that's why we're asking for the time served.
And Your Honor, if I may, I'd like to add that the defendant was convicted of terroristic threats in 2018 out of Douglasville. I believe he was given 5 years probation, but because that was violated, he had to serve time. He was also convicted of a riot in penal institution in 2018. Nothing further, Your Honor.
So you have no objection to the alcohol drug evaluation and treatment?
Do not, Judge.
All right. And do you know why he was at Grady seeking medical treatment? Was it something that was related to mental health?
I was under the influence and I didn't.
Okay, hold on. Hold on,
yes.
Mr. Green.
Yeah, Mr. Green, I'm not aware, Judge, of why he was originally there seeking medical treatment. I did not cover that with him.
In the report, it did state, after it mentioned him being under the influence, it stated a reasoning for why he was there. Maybe a partial reasoning. It wasn't super clear, but I won't sound on that reasoning. But you'll know what I'm talking about if you see the report.
Can you put it in the chat for me, Ms. Mitchell?
Yes, I can do that.
Thank you. Does he have a place to stay, Mr. Finley?
I do. Let's see if I can find. Yes, Your Honor. I do have an address for him. He's going to be staying with his brother on Hill Street in Atlanta. I can give that address to you if you need.
Okay, no, that's fine. I just want to make sure that he has somewhere to go. Anything further on Mr. Green?
No,
just that I did speak with Mr. Green, and he was we had a pretty deep conversation about kind of what he's been through the last over 2 years and kind of how he wants his life to progress from here on out, and obviously changing his ways, Judge.
All right. Mr. Green, it's my understanding that you wish to plead guilty to terroristic threats. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
Sir.
I'll accept your guilty plea, Mr. Green. The sentence is going to be 12 months to serve, 32 days, credit for time served, 16 days, the balance probated, an alcohol drug evaluation and treatment if necessary. Stay away from Grady unless you're seeking medical treatment. No drugs, alcohol, or weapons while on probation. I am going to waive your probation fees while you're on probation. And as soon as you complete the alcohol drug evaluation and the treatment if necessary, the probation is going to go to a non-reporting status, okay?
Yes, sir.
All right, good luck to you, Mr. Green.
Your Honor, just for clarification, that was 32 days confinement and credit for time for 16 days?
I have down that he's been confined for 16 days. Is that not correct?
It's been a 12, I have 12.
I have 12
That's correct.
days.
Okay, well, I only say 16 days because that's what it has on the calendar. So 12 days, 12,
Yeah, 24, I believe.
20, okay, so 12 months to serve, 24 days, credit for times served, 12 days.
Okay. Understood.
Thank you. Mr. Green,
Does that mean I have to do 24 more days?
No, sir. It's a time served. It's a time served plea.
So when I'll be going home today and go to anger management or drug evaluation?
It'll be within, as soon as we get done with court, I'm gonna submit your paperwork, sir, and as soon as the jail can, they will release you.
Thank you, sir.
Thank you, Mr. Green.
And Your Honor, that was 8-week anger management, or was it less than that? I'm sorry, I didn't hear.
it was the recommendation from the state was alcohol, drug evaluation and treatment, correct?
Yes, and an 8-week anger management course.
Okay, I don't have 8 weeks again on the calendar here, so he was not sentenced to 8 weeks anger management. I think this is more of a drug and alcohol problem as opposed to an anger management problem. So I'm not going to sentence him to anger management.
Understood. Thank you.
Okay. All right. Good luck to you, Mr. Green. Who do we have next?
I'm going back to 25, Mr. Shannon.
Okay. What are we going to do with?
And Judge, this will be a negotiated plea.
Okay. Let's see, Mr. Shannon. I believe we've gotten through the preliminaries, Mr. Segura.
Yeah,
Anything further?
none from my end.
Okay, would you just go back through the what the negotiated plea is for the record?
12 months to serve 108 days, credit for time served 54 days, balance probated, no further contact with Stephen Tutt, ADET, no drugs, alcohol, and weapons, and 40 hours community service.
And Judge, we would just ask for the probation fees to be waived, but yes, that is our understanding of the state's recommendation, and we do agree with it. We stipulate to the factual basis, venue, and ID.
Okay. Mr. Shannon, it's my understanding that you wish to plead guilty to disorderly conduct and simple battery. Is that correct?
Yeah.
Are you under the influence of any drugs or alcohol at the present time?
Nope.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yeah.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury? Has anyone forced or coerced you to plead guilty?
Nope.
I'll accept your guilty plea as negotiated, Mr. Shannon. I'm going to waive the fees while you're on probation to help you get and stay on your feet. Good luck to you, sir.
Got 23, Mr. Rowe.
Good morning, Mr. Rowe. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Did you hear what I said, Mr. Rowe?
Yes.
Okay, do you agree to have your case heard by video? You got to scooch closer to so that we can hear you. Okay. All right, we're doing this by video. Do you agree to have your case heard by video?
Yes.
All right, can you raise your right hand for me? You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you can put your hand down, Mr. Rowe. Thank you. Mr. Segura?
The plea is 12 months to serve 58 days, credit for time served 29 days, balance probated, 12 weeks anger management, 80 hours community service, a stay away from the 1345 Westridge Road, Southwest Atlanta, and no further violent contact with Devontae Rowe. Thank you.
Yes, Judge, that is our understanding of the recommendation. We do stipulate to the factual basis, venue, and ID.
Mr. Rowe, it's my understanding that you wish to plead guilty to battery. Is that correct? Yeah, you speak up. It's my understanding you wish to plead guilty to battery. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol today?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation? You understand that you have a right to a trial by jury, and by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anybody forced or coerced you to plead guilty?
Huh?
Has anybody forced you to plead guilty?
No.
I'll accept the plea as negotiated. And I will waive the probation fees while he's on probation to help him get and stay on his feet. It's my understanding that probation wants him to report by April 1st, but it's also my understanding that he's currently in custody on other charges, and I won't be able to make that April 1st date. Is that correct, Ms. Helen?
That is correct, Judge.
And that's fine. We just have to have it in the system. So we just have to have it in the system. They know what to do at the office.
Okay. All right. Thank you. All right. Good luck to you, Mr. Rowe.
We got number 4, Mr. Bibbs.
Thank you, Judge.
You're welcome. Good morning, Mr. Bibb. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yeah.
Is that a yes?
So what?
We're doing this by video, Mr. Bibb. Do you agree to have your case heard by over video?
Yeah. Is we
Yes.
on video? That's the question you asking me?
Yes.
Yeah.
Okay. Can you raise your right hand for me?
You say what?
Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
What courtroom this is?
Can you hear me, Mr. Bibb?
Yeah.
All right. Do you swear to tell the truth?
About what?
About whatever you're gonna about whatever questions I ask you.
I thought they were misdemeanor court.
All right. Are we having a problem, Mr. Finley? That I need to know about?
No, Mr. Bibbs, this is what we spoke about yesterday, the plea offer, and you stated you wanted to plead guilty to the time served.
It misdemeanor court, right?
Yeah, yes, sir. This is covering the disorderly conduct and obstruction that I met with you about last night.
Yeah, I take the time, sir.
Okay. If you could just answer Judge Morrow's questions, please.
All right. So let me see if I'll try this one more time, Mr. Bibbs. You're going to give some testimony in this case. Do you swear to you swear affirm that you're going to tell the truth to the questions that I ask you?
Yeah.
Okay. Ms. Mitchell?
Yes, Your Honor, the state's plea recommendation is time served, credit for time served 29 days, balance suspended, no further contact with Ayanna, spelled Iyonna, Cobert, spelled Cobert, a stay away from 2479 Abner Terrace Northwest, Atlanta. Nothing further, Your Honor.
Mr. Finley?
Yes, Judge. And we do agree to the state's recommendation of the time served and balance suspended. And additionally, Your Honor, we do stipulate to the factual basis, venue, and ID.
Mr. Bibbs, it's my understanding, for South, you're gonna have to unmute for us, please. Mr. Bibbs, I understand that you wish to plead guilty to disorderly conduct and obstruction of a law enforcement officer. Is that right?
I ain't do that to that officer, but I'm trying to get time, sir. I'm trying to get out of here.
Mr. Bibbs, if you could just answer Judge Morrow's questions with a yes or no, because you are getting time served. So if you could answer yes or no, please.
I plead guilty to get out of here, man. I'm trying to get time served.
Okay. Mr. Finland, I'm reticent to take a plea where Mr. Bibbs is indicating that although he wants to get out of custody, that he is not guilty of the charge. I am also willing to consider, is he been held on anything else? Is this all he's been held on?
We look into that once again. I believe so, Judge. No, I don't believe that he's being held on anything else, Judge.
All right, what's this current, do you want to convert this to a bond hearing possibly?
Yes, yeah, we could, sir.
But do we have his bond?
Is this over with?
No, we're still going, Mr. Bibbs.
He just said he granted me time served.
Could we reset this, Judge, and I can visit him?
He just said he granted me time served. What we were saying?
Yes, of course, Mr. Finley. We can reset it for next week. I have concerns about his capacity. If you want to bring him back next week, I'm happy to listen to whatever you have to say regarding this, or to possibly make a bond modification if that's what you want.
If we could do that, Judge Morrow, just so I could meet with him again and discuss this.
What I'm getting another meeting for?
Thank you, sir.
All right, 4 South. We're gonna reset him till next week. Did you get that, 4 South?
Say again?
We're resetting him till next week.
Okay. Got number 14 for you, Mr. Kemp.
Good morning, Mr. Kemp. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yeah.
Can you hear me, Mr. Kemp?
Yeah. Yes.
Yes, and you agree to have your case heard by video?
Yes.
Can you raise your right hand for me? You swear affirm the testimony that you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, Mr. Kemp. Ms. Mitchell?
Judge Morrow?
Yes.
If I could, there was an email sent out yesterday. I'm just pulling up really quick from Miss Lewis, I believe, that wanted to reset Mr. Kemp to the.
Yes, that's true. Mr. Kemp is in the MMC court, and they have him scheduled for tomorrow. So he's being evaluated again, and I guess to confirm his participation in that program. So he is set to be in front of the judge tomorrow, the 24th.
So can we reset him till Thursday, because this is a time served plea and I don't want him to have to stay in jail any longer than
Well,
necessary.
they're going to address him tomorrow in front of Judge Kurt. So from that point, if you can reset him to I
Is
guess,
it-
to Tuesday, if he does,
Is it-
if something doesn't go well with the program, but from my understanding, he is supposed to be participating in the program. They would just try to iron out some, situations regarding by his previous cases.
No, I understand that, but if we reset him till next Thursday, that means that if we reset him next Tuesday, that means that if things go well for him tomorrow, that he's gonna have to sit in jail for an
Oh,
additional.
no, they will give him a bond.
Judge, if I could, in the email, it says that he's being sent out by Mr. Jordan yesterday. It said, Mr. Kemp is being reset to Thursday, 3/24's mental health court calendar. So that was my understanding from this email, that he's being reset to Thursday.
That's correct, which is, the 24th.
Right. So, and then I'm assuming then we can, because I agree with Your Honor, it is a time served deal. So I would hope you can get out.
So what time, well, if the mental health court's on Thursday, then he's probably not gonna be able to make anything but the mental health court, and the next court that we would have would be the next Tuesday. Right?
Yeah, I mean, so I met with Mr. Kemp yesterday. I didn't see the email until I got out because obviously I didn't have access. So I met with him, prepared for him today, and it wasn't until after that I saw this email.
All right, so what would you like me to do, Mr. Kramer?
So if he's reset till Thursday, he can still accept, I'm assuming, this plea, correct?
But it's my understanding from what Ms. Lewis is telling me that if he's going to mental health court on Thursday, that he would necessarily possibly not be able to come to SAP calendar, right?
Yeah, Honor, if I may, on Thursday, it's my understanding that the defendant will be able to take a plea. It will be the same recommendation. However, a condition would be to maintain compliance with the mental health court. So he'll still have the same opportunity to take a plea. I think they just want to further evaluate him to see if he's a good fit for the program. If so, he'll take a plea with the conditions of, because that program is pre or post conviction. So that's my understanding. What's going to take place on Thursday. And if he's not a good fit, he can still take a plea, but it just won't be mental health for it.
Okay, all right. So I guess we just need to find out what happens on Thursday. All right.
Okay. That sounds good.
Okay.
Thank you,
All
Judge.
right. Thank you, Forsyth. Who do we have next?
Position 11, Mr. Jackson.
This is a non-negotiated plea.
That's correct, Judge.
Let's see. Good morning, Mr. Jackson Sutherland. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have the case heard by video?
Yes.
Thank you. Can you raise your right hand for me, sir? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. And it's my understanding that Mr. Jackson Sutherland is position 11 and position 12.
That's correct. Are you with me, Ms. Mitchell?
Yes, Your Honor. I didn't hear you call for me. I'm sorry.
That's fine.
The plea recommendation is going to be 12 months. Well, it's a consolidated plea for position 11 and 12. 12 months to serve, 60 days confinement, credit for time served, 17 days, balance probated, no further contact with Samisha Johnson, stay away from 2025 Peachtree Road, Northeast, Atlanta, Georgia, FVIP, 40 hours community service, and no alcohol, drugs, and weapons. So, Your Honor, in this case, on position 11, on December 27th of 2021, the defendant battered Ms. Johnson, his girlfriend, another person living in the same household, by grabbing and biting her, causing a laceration on her left thumb. It started with a verbal dispute about cleanliness of their apartment. And then a month later, on January 30th of 2022, the defendant pushed Ms. Johnson during a verbal dispute that caused her to lose her balance and fall to the floor. The defendant is a convicted felon. He does have several felony drug convictions with a pending case from 2021 for possession of cocaine. The defendant also has 2 convictions of carrying a deadly weapon and 1 conviction of a gang-related activity. We do have concerns of witness intimidation in this case, being that the defendant and the victim have been in a relationship for 2 years and have lived together. And this happened within a 1-month period. We're also concerned that the defendant is a flight risk, and that he has 6 failure to appears and 4 probation violations with a prior First Offender Act revoked. So based on all that, that's going to be the basis of our plea recommendation, Your Honor.
Yes, Ms. Johnson, I'm going to allow you to speak if you'd like to, but I'll call on you in turn, okay?
Okay, that's fine.
All right, Mr. Finley?
Yes, Judge. I did speak with Mr. Jackman Sutherland yesterday to go over this plea offer. As we heard, the state is asking for 60 days confinement, which after the 2-for-1 and credit for time served would be 13 additional days incarcerated. We are asking for time served, Judge. Took him a very long time to find a job, and he did indeed find a job at Cura Revolving Sushi in Norcross. They really like him there, and he's hoping that he still has that job once he gets out. I did also speak with Miss Samisha Johnson, who stated that she does want contact with Mr. Jackman Sutherland. So she wanted to speak on his behalf to that no contact, sir.
All right. Ms. Johnson, if you would like to speak, I'll need for you to raise your right hand.
Oh, that's the wrong hand.
You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, put your hand down, ma'am. What would you like to tell the court?
I would like contact with Mr. Sutherland. We do have a baby on the way. And so it would help out a lot. I do not feel threatened or intimidated by Mr. Jackman whatsoever. And concerning his job, he does still have his job. He just needs to go down there and talk to the management.
All right. Are you and Mr. Jackman living together?
Yes, we are living together, and we also have a baby on the way. And as of right now, I'm scheduling for us to do family. I think it's called family treatment. It's where, it's like some kind of family therapy. Because basically, we have a child on the way, so we need to find a different way to communicate than what we've been doing besides, arguing and everything.
And Judge, I do have an address in Snellville for him. I don't believe, do you live there together, Miss Samisha?
No, I do not.
Okay.
Actually,
Okay.
His stuff is actually over there. So that's where he'll be staying at.
Understood. So I do have that address, so I believe is not, if you do decide that they can't live together, Judge.
All right. And Ms. Johnson, it's in December of last year, you had to call the police regarding an argument that you all were having. Is that right?
Yeah, it was an argument that got too loud, and basically the leasing office took it way out of hand. They took it out of the hand the first and second time. And the argument is not about the cleanliness. The argument is about basically, the baby, because if we're not getting along, then, we need to find other ways around that where we can co-parent. And I think, if we can't get along and be together, then co-parenting would be the best thing for us. But as far as threatening and me being afraid of him, no, I am not. I would like him to be a part of his child's life because this is his first child. And, you know, it would be a good experience for him. He has changed a lot. Like I said, he does work at he does have a job. He still has his job. So, I mean, you know, it takes time to change, but he's slowly doing that.
All right, thank you, Ms. Johnson, I appreciate it. Anything further, Ms. Mitchell, Mr. Finley?
No, Your Honor.
No, Your Honor, I would just also ask that probation fees could be waived, Judge.
All right, Mr. Finley, I'm inclined, given his history, to accept the state's recommendation on this, given Ms. Johnson's testimony here today and the fact that he's about to have a child. I'm reticent to keep a father away from his child, and given that he will have family violence intervention, hopefully that will assist with them and how they relate in the future. So I'm going to give him that opportunity to be a part of his child's birth and his child's life. So there'll be no further violent contact. Other than that, the recommendation of the state will be adhered to if that's something that he wants to take.
Did you understand that, Mr. Jackman Sutherland?
You understand that? Remember when I spoke to you yesterday about the pretrial?
Yes, and I understand. I do have a message sent out, and I am looking into that. That's another case that I don't represent you on, but I'm happy to try to look into that for you.
So, I mean, I understand that, but at the same time, I'd rather not plead guilty to this if I'm not gonna leave the jail, if I'm still gonna be inside the jail. If I'm still gonna be incarcerated, I might as well sit here and get my time served, waiting on pretrial. Because I can't leave.
Understood. Well, if you do not have, this is ultimately your decision, Mr. Jackman. So if you want to plead not guilty, then we could do that today.
Because I won't be able to leave because of pretrial. I'll still be sitting in jail.
I understand.
And then I wouldn't be able to report on the first to probation because I'll still be sitting in jail.
So we could, do you want to proceed not guilty and we can address bond?
Yes, sir.
Okay, so that's what we'll do, Judge.
Okay. Let's see, Mr. Jackman Sutherland, you've been charged in case 22 CR 001225F with battery family violence, and in case 22 CR 001226F with simple battery family violence. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusations, Mr. Finley?
I do, Judge.
How do you plead, Mr. Jackman Sutherland, to these charges, guilty or not guilty?
Not guilty.
All right, we'll record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. Let's see. I set these bonds back on March 7th of this year. It's $1,000 good bond on each charge.
I think, Your Honor, I think we could, because he did say he could pay for this, so I think we could just probably stick to what the current bond is and just have this as an arraignment.
Okay, all right. He has his hand up again, Mr. Finley.
Yes.
You said you told me it was $1,000 each charge good bond, but in the computer it's reading as $4,000. Like when my family called the bonding companies, they said it was my bond was $4,000. Is there like a clerical error or?
I'm seeing 1,000 for each. It's 2,000.
Mr. Finley, the bond company can tell you the price that they're going to charge you to bond you out, but what's reflecting is a $2,000 surety bond. So you want to contact the bonding company and see if they're charging you an extra fee.
Okay.
Which it should be. Yeah, they should be covering 10 to 15%.
Sorry to
I mean, he'd be
interject.
responsible for protection.
Sorry, and I'm not trying to give him advice, but he's being held on a no bond on a felony offense, so that's kind of a moot point.
Right.
FYI.
Understood. Yeah, that's why I was thinking it's probably
Okay,
an
so that,
arraignment. Yeah.
so this is not, his big issue.
Right.
Okay.
That's what I was thinking.
All
Was
right.
an arraignment.
Ms. Johnson, anything further? I saw that you had your hand up.
Yes, I just wanted to know if you allow me to have contact with him, because, you know, I can still like communicate and let him know how the ultrasounds are going. And just in case he's not able there, if he's not able to make it to the birth, you know, just to give him updates and everything.
If he gets a bond on the other matter, Ms. Johnson, Mr. Finley can bring him back here for bond modification for me. But at the present time, it doesn't appear that, given that he's on a no bond status, that's not what's holding him in. But if he does get a bond and can bond that on that other case, then you can certainly come back before me and request that, okay?
Okay.
All right. All right, good luck to you, sir. You also, Ms. Johnson.
Thank you.
What do we have next?
Next we have, come on, sir. Mr. McFarland, position 18.
And this is non-negotiated, correct?
That's correct, Judge.
Good morning, Mr. McFarland. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, Mr. McFarland? Do you swear affirm the testimony you're about to give before the court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. Mr. Segura?
The plea from the state would be 12 months to serve 40 days, credit for time served 16 days, balance probated, a stay away from the Kroger located at 2452 Moles Go Way Northeast, and an ADET.
Yes, Judge, this is a, oh, I'm sorry, go ahead.
Organization lawsuit based on the facts included that the loss prevention security guard informed police that the defendant, who appeared to be intoxicated, was sitting on a handicapped cart in the Kroger. When approached the defendant, this kind of relates to the indecent exposure. Mostly, let's say he was relieving himself of being visibly seen in public by anyone, the police and anyone who could see it. And was also displaying erratic behavior by shouting a loud voice and was walking in a distorted manner toward the cop. And he called the police a BITCH and a HOE a couple of times. And from the police report, it is noted that the defendant exuded a strong alcoholic odor, and he had slurred speech, unsteady walking, and was talking to himself. Thank you.
Yes, Judge. This is a non-negotiated plea. However, Mr. McFarland has been arrested on a failing to appear from April 12th, 2021, last year with Judge Law for a plea and arraignment. There are not new charges in this case. That's why we're asking for time served. I believe with the state's recommendation, it'll be 3 additional jail days. But for Mr. McFarland, I am asking for time served. He understands there's a stay away from that Kroger's at 2452 Marseille Way, Northeast. I also have here that he did 3 additional days in 2021, bringing the credit for time served to 17 days. So again, Judge, I am asking for this case for the failing to appear for time served balance suspended. I do have a good mailing address for him at a 201 Washington Street, Southwest Atlanta, Georgia, 30303. And I don't believe that there is a return sender from that address, Judge.
All right. What's the history, Ms. Harrison?
One moment, John. "18 cycles." Last conviction was November of 2020 for theft by shoplifting in Doraville. A 2002 DUI. So just the one arrest within the past 10 years.
Okay. Anything further, counsel?
No, Judge.
No, Judge.
All right. Mr. McFarland, it's my understanding that you wish to plead guilty to public drunkenness, disorderly conduct, and another misdemeanor offense. Is that correct? You're on mute for him too.
Sorry.
Is it, let me start from the beginning, Mr. McFarland. It's my understanding that you wish to plead guilty to public drunkenness, disorderly conduct, and a third misdemeanor offense. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
All right. I'm going to accept your guilty plea, Mr. McFarland. The sentence is going to be 12 months to serve, 34 days, credit for time served, 17 days, balance probated, alcohol drug evaluation and treatment, and to stay away from the over on the Morosco Way address. I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And once you complete the alcohol drug evaluation and treatment, then the probation is going to go to a non-reporting status, okay?
Yes, sir.
All right, good luck to you, Mr. McFarland.
All right, next we got position number 2, Mr. Bates.
Write this down.
Mr. McFarland, they're giving you the place to report, okay? So write that down.
Let's see, probation.
Yes.
It might be helpful if, and I don't know if you can do this or not, but if maybe we can get some cards printed up or something and have your location and it has a date, so all they have to do is write the date in and they'll have the card or something.
See, the problem is they have, the public defenders have our judicial service corrections form that they're supposed to fill out for the defendant.
Okay.
Give to us, but some of them not sending them in. So I can't call these people that I don't have because I don't have information on them at all.
Can we talk about that, Judge? We're sending a probation sheet with an address, contact, your name, the judge's name, the case number to T.S. Allen in probation judicial services, as well as 2 other people. If we need to put you on that email address, we can, but we have a complete form that they told us to fill out for the probation individuals. But I don't know if it has that address on there, or I don't know if it's that form.
What's the correct email address? I'm not sure if I'm
It's
it's
D Thomas, as in Donna Thomas, the number 2 at judicialservices.com.
Okay, I don't believe we had that email before, but we'll take it down now and we'll start including you on the SAP listservs that we do with the case manager and the judge and different other attorneys. And you said D as in dog, Thomas, the number 2?
Yes.
Okay.
At judicialservices.com.
Yes.
Got it. Okay. We'll make sure we get those to you. Thank you.
So the defendants, because I have several here now, so the defendant don't have a sheet to them at all. How am I getting those?
We're going to email them to you at the end of the SAP calendar.
I have a stack here that has no information at all.
So they don't have any contact
No
information,
contact,
no
no nothing.
address for those people.
I can't call nobody. I don't have an address. I don't have a phone number.
So wait. From this calendar, you don't have a
No, I've been sending emails from 3/17 and 3/9 saying that I need information for these people. The same information that was sent to the list of everybody, of all the public defenders, the judges, I send all these emails giving you my information so that I can get this information.
What are the dates that you're missing, just so I can make sure that I send?
I was about to say, we can
March
send you the.
17th. Give your names, or we can do this after court once he.
Yeah,
Okay.
we'll have to set up a time to do this.
Okay.
We didn't have that form, so.
Get together and whatever you need, just see if you can work it out for the court. And then once you do, Ms. Helen and Mr. Finley, if you could report to the rest of the public defenders that this is going to be how you're going to do it going forward, so that the probation department can get everything that they need in a timely manner. Okay, can we do that after court?
Yes, sir.
Yes, sir.
All right, very good. Thank you all. All right, so this is Mr. Bates.
Yes, sir.
Good morning, Mr. Bates. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Let's see, this is going to be a non-negotiated plea, Mr. Finley.
Yes, sir. And we're just addressing the
Jail time?
jail time. Yes, sir.
Okay. Can you raise your right hand for me, Mr. Bates?
Sir.
Can you raise your right hand for me? You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, correct.
Okay, you can put your hand down, Mr. Bates. Thank you.
And I apologize, Judge. I want to address actually the balance probation suspended. So I guess
Okay.
it will be non-negotiable.
Okay, you can address whatever you need to, Mr. Finley.
Okay.
Ms. Mitchell.
Yes, Your Honor, the state's recommendation is 12 months to serve, 60 days confinement, credit for time served 16 days, balance probated, a stay away from the Georgia Tech campus and transportation, SDET, 40-hour community service, and no alcohol, drugs, and weapons. Your Honor, in this case, the defendant was seen exposing himself, his genitals, and fondling himself while sitting on the Georgia Tech Stinger bus. The defendant knowingly and intentionally rode the Stinger bus on Georgia Tech's campus after having an active criminal trespass warning that was set to expire on April 5th of 2023, so next year. The defendant in this case has an extensive criminal history. He is a convicted felon. He appears to have 31 cycles in Georgia and 25 cycles in Alabama. Of that, in Georgia, he has a criminal trespass conviction in 2021, 2 disorderly conduct convictions in 2020, another criminal trespass conviction along with a simple battery in public transit vehicle in 2019, an aggravated assault in 2019, and another criminal trespass that was amended to disorderly conduct in 2018. On top of that, he has over 20 failure to appears and several probation violations. We also see another public indecency case that appears to be open from September 5th of 2021. So based on that,
Can I correct that?
Mr. Bates, I would strongly advise you just to let me speak for you, sir.
Okay, go ahead.
So that's going to be the basis of our plea recommendation, Your Honor. Nothing further.
Is that pending in Fulton County?
I'm about to double check that for you right now. Not in my notes. That is in it says Marta Police Department.
Ms. Harrison, do you know if he has another pending case?
Not showing an open case, Your Honor.
All right, thank you. Mr. Finley?
Yes, Your Honor. We are asking for, if he could have, let's see, time served judge. We do have someone that's going to speak with him to make sure he has stable housing. Also, we would be asking that after he does complete the SDET, if his balance could be suspended. I just feel like with Mr. Bates, having him on probation just could be a recipe for him ending up right back in jail, Judge. So we are asking that once he does complete that, if he could be either balance suspended or not reporting judge.
Your Honor, I do show he's currently on felony probation.
Okay. And what was the underlying charge?
Aggravated assault, possession of firearm during the commission of a felony, also a burglary. So it's 1, 2, 3, 4 open probation.
How long has he been incarcerated on this, Mr. Finley?
Pull that back up, sir. I believe it's been, looks like 16 days.
And you're going to have a social worker work with him as far as
Yes, yeah. When I spoke with Mr. Bates yesterday, he did said he needed some assistance with housing, excuse me. So I am going to have a social worker speak with him to get him some information on housing.
all right. Anything further, Ms. Mitchell, Mr. Finley?
No, Your Honor.
Nothing further, Judge.
All right. Mr. Bates, it's my understanding that you wish to plead guilty to criminal trespass and one other misdemeanor offense. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
I understand. Yes, I understand.
Has anybody forced you to plead guilty?
No.
Okay, I'll accept your guilty plea, Mr. Bates. The sentence is going to be 12 months to serve, 32 days, credit for time served, 16 days, balance probated, an SDET, and stay away from Georgia Tech campus and transportation. No drugs, alcohol, or weapons. While on probation, I am going to waive the probation fees while you're on probation, and once you complete the SDET, the probation will go to a non-reporting status, okay?
Yes, sir.
All right, good luck to you, Mr. Bates.
What is that?
If you got 26, Mr. Spencer.
Excuse me, Judge, before we move on to that next case, because I'm getting ready to close out. For position 9, he wanted to know his reporting status as far as Mr. Green. I was trying to send a chat to you, Mr. Finley.
Oh, I apologize.
He should report by April 1st, on April 1st, to the 132 Mitchell Street address. That's in the chat. Is that what he was asking for?
Yes. Okay, the Mitchell Street.
He has to be there at 9:30 on 132 Mitchell Street.
Go ahead, yeah, write that one down. Okay. Thank you.
Okay.
Also, Judge, I'm sorry, also Judge, we're completed here in courtroom 2.
All right, so everyone else is going to be at 3 South today. We
That's
have
correct.
We have position 22, I believe. And position 22, position 26, Aaron Spencer, and position 33. No, we've done 33.
I think we did 33, Judge. I have 19, 22, 25, 26, and 20. That's it, 26.
We did 25.
Oh, yeah, we did 25. Sorry, guys.
I have 22 and 26. Is that right?
Yeah, 26 right in front of me. Who is 22?
22 is Mazio Quillian.
Did I miss that we did 19?
I've got down that we did 19.
Okay.
Yeah, so it's a negotiated plea.
What's the booking number 19?
We've done 19. That was Mr. McQuiller.
Okay.
I've got 22 and 26 that we
What's
still
booking
have.
number 22? I'm sorry.
22 is Mazio Quillian.
You got a booking number for him? Let's see if I can look him up real fast.
Is that the same as the case number?
No, it's
No,
21, it's 2103607.
21 what?
2103
Uh-huh.
607.
Okay.
Okay, so while we check on Mr. Mazio, let's go to Mr. Spencer. Position 26. This is non-negotiated.
Yes, sir.
Good morning, Mr. Spencer. Can you hear me okay?
Yes, sir.
I'm Judge Eric Morrow. This is the state court all-purpose calendar. We are conducting this calendar today by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Sorry?
We're doing this by video. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down, Mr. Spencer. Mr. Segura?
The state is recommending 12 months to serve 90 days, credit for time served 15 days, balance probated, 8-week anger management, 40 hours community service, a stay away from Georgia Tech, and no further contact with Sean Alexander. Basing our recommendations on the facts that the defendant struck the victim, Mr. Sean, in the face with a closed fist, causing swelling and substantial redness. But the police report noted that the victim does not know the defendant at all, and the victim is a Georgia Tech student. Our recommendations also based that he has a long criminal history, one originating from Michigan as well from Georgia, relating to assault and batteries. Thank you.
Can I hear that history, Ms. Harrison?
There are 18 cycles with history out of Michigan. Last arrest was June of 2021 for a probation violation in Fulton County. Underlying charge was not indicated. Record does indicate the defendant has an open case pending for aggravated battery, case 22 SC 180465, for failure to appear within the past 10 years.
What year is that open case from?
It's recent, 22. That case number is 22 SC 180465. The arrest appears to be February of 2020.
Anything further?
No, Your Honor.
Thank you. Ms. Heller?
Yes, Judge, this is a non-negotiated plea. We are asking for a sentence of 60 days. We do agree to the year of probation. We do agree to the reporting, the 8 weeks of anger management, the 40 hours of community service. He understands the stay away from Georgia Tech. I have a specific location, not all Georgia Tech locations. I have the position of 120 North Ave, Northwest Atlanta, Georgia. And when I spoke to Mr. Spencer, he does not know who Sean Alexander is. They're not friends. They don't know each other. So there's no issue with the stay away or the no contact with Mr. Sean Alexander. But we are asking for a recommendation of 60 days to serve and not the state's recommendation of the 90.
Your Honor, I would say that for the stay away, it would be the entirety of Georgia Tech because the victim is a Georgia Tech student, so we're uncertain as to what location he might be in during his enrollment. So it could be that it could be in any single location in Georgia Tech.
Is there an indication, Ms. Helen, as to why this occurred?
Yes, when I talked to Mr. Spencer, again, he does not know Mr. Alexander. I do believe that it may have been some involvement with a substance. But again, when I spoke to Mr. Spencer, he understood the charges, he remembered the case and wants to resolve it, again, with just the recommendation of 60 days to serve and agrees to the conditions. If the condition is to stay away from all Georgia Tech locations, that is agreeable to, Your Honor.
I was asking because I want to know if it's an anger issue or if it's a alcohol and drug issue.
The second one, Your Honor.
Okay. So my inclination would be that instead of the anger management, that he gets treatment for alcohol and alcohol drug evaluation and treatment if necessary, as opposed to the anger management, as I think that might be more his issue. Okay. So anything further?
No, I do believe that Mr. Spencer would agree to the alcohol drug evaluation and treatment, Your Honor. So yes.
All right. Anything further, Mr. Segura?
Not on my end.
All right. Mr. Spencer, it's my understanding that you wish to plead guilty to battery, substantial physical harm. Is that correct? You have to say yes or no for me. Yes?
Yes.
Okay. Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on this offense and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anybody forced you to plead guilty?
No.
I'll accept your guilty plea, Mr. Spencer. The sentence is going to be 12 months to serve, 60 days, credit for time served, 15 days, balance probated, alcohol drug evaluation and treatment if necessary, 40 hours of community service, stay away from Georgia Tech and no further contact with Sean Alexander, no drugs, alcohol, weapons while on probation. If I'm going to waive the probation fees for you to help you get and stay on your feet. Once you complete the alcohol drug evaluation and the 40 hours of community service, it's going to go to a non-reporting status, okay? All right. Good luck to you, Mr. Spencer.
Thank you, sir. So just to clarify, that means I have 15 days remaining?
What was the sentence again, Judge, just for clarification, serve?
60 days, credit for time served, 15 days.
So that'll be 15 additional days, won't it, Mr. Spencer?
Thank you.
Thank you.
So were we able to locate Mr. Quillian?
Yeah, he's on 2 North, courtroom 2, about to go get him now.
Okay, all right, thank you. So while we're waiting on courtroom 2, is it possible to go over the calendar? All right, I'm gonna have Ms. Middlebrooks go over the calendar while we wait on courtroom 2.
Did the officer say he was going to go get Mr. Quillian? I entered a waiver of appearance and arraignment for him, so hopefully we can catch him before he runs out. to get
Okay,
Mr.
well, that's
Coogan.
who we've been talking about this whole time, Ms. Helen.
Yeah. But I entered in a waiver of appearance, or I will be entering a waiver of appearance and arraignment for Mr. Quillian. I apologize.
All right, so given that we're gonna get a written waiver. So what is he?
It's going to be a not guilty jail jury, no bond hearing.
Okay, so it's just a waiver of arraignment, correct? And that's
Correct,
it?
Judge.
Okay, so you file your written waiver. Can somebody inform courtroom 2 that he's not needed? Or I don't know if there's still someone there. All right, let's see, whenever you're ready, Ms. Middlebrooks.
Position number 1 was a plea. Position number 2 was a plea. Position number 3 was release. Position number 4, reset SAP 329. Position number 5 was arraigned, not guilty. Reset SAP 329. Position number 6, reset SAP 329. Position number 7, reset SAP 324. Position number 8, reset SAP 324. Position number 9 was a plea. Position number 10 was arraigned as a not guilty, reset jail jury. Position 11, arraigned, not guilty, reset jail jury. Position 12, arraigned, not guilty, plea, reset jail jury. Position 13 was a plea. Position 14, I put down he was reset to SAP 329, I guess depending his outcome on Thursday, 3/24. Position 15, 16, 17 were all pleas. Position 18 and 19 were pleas. Position 20 was arraigned, not guilty. He received a bond modification of $5,000 sign-on bond through the jail. Position 21, reset SAP 329. Position 22, that's a waiver of arraignment. Are we, Ms. Helen, we resetting that to jail jury?
Yes.
Okay. Position 23 was a plea. Position 24 was a plea. 25 was a plea. 26 was a plea. 27 was a plea. 28 was a plea. 29 was a plea. 30, a plea. 31, a plea. 32 was released. Position 33 was a plea. On the add-on calendar, position 1 was a plea. And the probation calendar, position 1 received time served.
All right.
And I just want to clarify, because I guess I'm still a tiny bit confused. So with the Mr. Kemp, so because just that, I'm just going off the email that was sent by Mr. Jordan. So it just says that he's being reset to Thursday's mental health, or mental health court calendar. So that's
He's
because I
going
know
to Thursday's mental health calendar. If he joins the program and they decide to give him a bond, he'll have a bond on that day. If he chooses not to participate in the program on Thursday, he's going on Tuesday's SAP.
So I believe Mr. Walker, I don't know if you can chime in, said that he'd still be, I just want to clarify, he'd still be able to accept that time served plea on?
So mental health court can be done pre-conviction or post-conviction. So he can be given a signature bond and participate in the program pre-conviction, or he could take a plea and participate post-conviction. So I mean, that would be something that had to be ironed out Thursday.
Okay.
But I do think it's in his best interest to wait till Thursday.
Got it.
To be admitted to the program if possible.
Understood. All right. Thank you, Mr. Walker.
All right, anything further today?
Can we stay on a little long so we can talk to probation, make sure we can get her all the documentation?
Yes, I can do that.
Here.
I can stay on. I will just stop the recording. That's all.
Okay.
All right, and I will just let you all work that out. Okay?
Okay.
Thanks, Judge.
All right. Thank you, Judge.